Hello, I am Hatef, and I will explain the key points of judgment upon constitutionality of the prefecture's expenditure from public funds to religious corporations which held ritual ceremonies. This is a lawsuit that disputes the constitutionality of spending public subsidy to the region-related organizations, especially for the Ehime governor's decision to allocate money for the religious organizations. From 1981 to 1986, when Appili Shiraishi held office as the governor of Ehime Prefecture, Appili Nakagawa, who had been the chief of the Tokyo office of Ehime Prefecture, contributed 45,000 yen from public funds as tamagushiryo to religious corporation Yasukuni Shrine when it held its spring and autumn ceremony. The issue here has been whether the above expenditure from public funds was the prefecture's unconstitutional financial act under Article 20, especially for the third one, or Article 89 of the Constitution. The appellees contended that the offering of tamagushiryo has the same meaning as the offering of saisen, which is to offer some money to shrines or temples when we visit them. However, saisen is generally offered anonymously, so it is clear that the offering of tamagushiryo in the name of local government is different from the offering of saisen in local meaning. The judgment by the Supreme Court was unconstitutional. In order to judge this sequence, the judges had to make sure the criteria, which is called Mokuteki Koka Kijun in Japanese. Mokuteki Koka Kijun is derived from the concept of the separation of religion and politics. Why do we need such criteria? For example, for a private school related to a specific religion like Christianity, to ban giving public assistance or to ban subsidies for religious cultural properties might cause distortion in the society. So, even if we have to say the separation of religion and politics is needed, we cannot completely eliminate the connection between the diet and religion. A certain number of connections have to be allowed for the specific cases like private school, as I mentioned. So, we have to think about the standard or the criteria of which case and to what extent the connection between the state and religion is recognized by the Constitution. Only the activities exceeding such reasonable limits should be prohibited. This criteria is separated into two sections, as it is obvious, the objective and the effect. The objective is concerning that is the purpose of a certain act itself religious, and the effect is concerning the outcome of a certain action, like is the effect helping or promoting a specific religion? The judges strictly followed this criteria for this lawsuit and sentenced the unconstitutionality by saying the following.